So I wanted to draw this up to help you guys to understand the manner in which the family court operates in terms of the balance of probabilities, contrast to the criminal justice system, which is beyond reasonable doubt. So this is how a balance of probabilities works. There's a scale to ascertain what is a fact, and the basic principle is everything operates that everything that is considered is entirely possible. Okay, so we're starting from this position here. So when someone says something, it's entirely possible, unless it's a statement like he flew to the moon without a rocket pack. Is obviously impossible. So we're working on the basis that whatever statement is made is possible. So when your ex is making a malicious allegation, it's not considered malicious because it's entirely possible at the point that the allegation is made. So everything that's mentioned is working from this point here, and this is why it can be incredibly frustrating when allegations are made and you know them to be untrue. The difficulty is other people don't know them to be untrue, so the burden is on you to determine which way that possibility scale goes. So what you're looking at here is on the bottom we've got something that's entirely impossible, and the example here is you cannot be in two places at one time. So what I want you to do is think about other things that are impossible. What cannot be possible? Think about your case, think about particular evidence or statements or things within your case that are entirely impossible, and list those out, because this will help you to determine what is entirely malicious. Okay, and you can prove those when you have a pattern of behaviour, like 2 or 3 occasions where statements have been made that are entirely impossible. So that's really helpful. So think about your case in that sense. Things that are improbable. Now this is going to be really helpful, particularly when it comes to things like fact-finding hearings and so on. The arena of what's improbable, if you can demonstrate these, so things like inconsistencies with statements, conflicts of statements between the statements that your ex has made, and statements between CAFCAS police officers, all this sort of stuff. So things that are inconsistent, you want to flag those up, make notes of those. So if your ex is saying, I think that the child is doing very well at school, and the school is saying the child is not doing very well, flag that up. That's an inconsistency, so you want to make those points. So this is the arena that you want to do. This is essentially where you're working. You're not working strictly on the defensive, you want to be on the offensive. So you want to take statements that have been made and show them to be improbable and impossible. In terms of probable and likely, this is the arena when you're working on things that you're asserting. So you want the statements that you make, you want to demonstrate that they're likely, probable and get them to the place where the judge is going to determine them as fact. So things that are likely, things that are consistent with one's character. So if your ex has behaved in a particular way and you want to demonstrate that, you want to go over your case and think of things that are consistent with that manner of being. The types of things that they say, the types of things that they do. You want to form an argument around that particular statement, the things that you're trying to assert about that person. So it may not be simply about their character. Whatever assertion you're making, you want to find things that are consistent with that in the that you can refer to in the bundle. The same as probable. So probable is the better position to be in. So not just things that are likely, but things that are probable. What you're doing here with these two positions is you're establishing your reasoning for why you're making particular assertions. And what I would say before we go forward any further is if you cannot establish a foundation on these two things, then it's possible that what you're asserting is anecdotal rather than factual in terms of the way that the courts would see it, and it may not help your case. So you want to always make sure that you're asserting things that you can demonstrate are either likely, probable or fact. So in terms of probable, things that are consistent with historical action. So you want to consider what things have taken place beforehand and that are likely to take place again. You can assert that these are probable because they've been done before. So it's not simply consistent with the character, but it's consistent with a person's action. Once these things are established, you can obviously put these in your position statement, or in your witness statement if you're in a fact-finding hearing and you're looking to draw conclusions at a hearing, and then the judge will ascertain whether they're fact or not. Now, there's a chance that you can establish things as fact. This is where things become on a beyond a balance of probabilities and are established as beyond reasonable doubt. So, for example, something there might be something that is corroborated by CAFCAS, police, social services, where they're all saying the same thing and you're also asserting that thing as well. That can be considered as something of fact. Another example is where, say for example, your partner has been in prison for a particular thing. That's a fact. That's an assertion that you can make. So it's not simply probable or likely, it's a fact. So you want to distinguish these three factors with any assertion you're going to make. If things are improbable or impossible to prove, then you need to consider that it might be something that they will only consider as possible, but it may be that your ex can make it seem improbable or impossible and may harm your case. So just consider those things. It's a really helpful exercise to approach. I wrote this up because I thought it'd be the most helpful way to explain it, but I hope that's helpful to you guys.